Getting an MOT is fairly simple, but so is getting things wrong. And there is one major mistake that lots of people seem to make and don't even realize it's a mistake until it's far too late, that I'll be covering in this video. But if you do fall for that trap, you might end up with a £2,500 fine, points on your license, and if you get caught doing it again within 3 years, there's a mandatory disqualification period of 6 months. So let's wind back to the beginning and take a look at the very basics of an MOT. This very useful guide on the gov.uk website, as many of them are, takes you through the requirements for a vehicle to have an MOT. Now, it might be trite information for most people, but for those new drivers among you, there is a requirement for a vehicle to have an MOT to park or to drive it on a public road. You must get an MOT certificate, which is a certificate of safety and roadworthiness of your vehicle, within the first 3 years of its registration, its first registration, that's when it's brand new, and every year thereafter. Some vehicles, such as ambulances, taxis, private hire, etc., need to be tested at 1 year old. And there is a useful table here that shows you at what age the vehicle first needs to be tested. And so, as I say, not many of them are 1 year, but the majority of passenger vehicles are after the first 3 years. You can check the MOT history of a vehicle by clicking this link here. And if the MOT has run out, again, most of you probably know this already, but if the MOT's run out, you cannot renew the tax for your vehicle if the MOT has expired. Now, it's a stark warning that you cannot drive or even park your vehicle on a public road if the MOT has run out. That could mean you get prosecuted. You can have up to £1,000 fine for driving a vehicle without a valid MOT certificate. The only excuses are going to and from somewhere for it to be repaired so that it will pass the MOT test, or to a prearranged MOT test. Now, it should also be argued here that this should be a relatively local garage. You'll have to go some way to explaining why you're driving it to the other side of the country to get it repaired. But in this video, I do need to emphasize what the MOT certificate is and what it is not. Now, an MOT certificate is a certificate of roadworthiness of the vehicle at the point in time that it was tested. It is a legal requirement to have one when the rules stipulate, and to drive without one is an offence for which you can be prosecuted. But as I say, it is a certificate of the vehicle at that specific moment in time. It is valid for that moment and satisfies the legal requirement to have and to drive it with a valid certificate. However, now we come on to the problem that many people don't realise and many people end up being prosecuted for on a completely different section of law that they are not aware of, which is Section 40A of the Road Traffic Act 1988. This is using a vehicle in a dangerous condition. Because let's just back up and pause for a moment. If your vehicle receives a valid MOT certificate and it leaves the garage, perfectly roadworthy, nothing wrong with it at all. But then let's say you have a minor collision, whether that's with another vehicle or a wall, for argument's sake. And let's say it damages the suspension or the tyres or any other part of the vehicle that would be required to be tested under a standard MOT. Then you continue to drive the vehicle. Now, this is where this other offence comes in, because a lot of people mistakenly assume that because it's got an MOT and it's valid, it's therefore been certified safe to be on the road, and they just think to themselves, well, I don't want to pay for the repairs, it still drives, it's still drive-worthy in their mind. They don't necessarily consider it to be dangerous. However, using a vehicle in a dangerous condition is a fairly serious offence, for which there are only really 2 defences, which I'll come back to in a moment. Now, this provides that a person is guilty of an offence if he uses or causes or permits another to use a motor vehicle or a trailer on a road when. Now, just pausing before the when bit, this first section means if you use it, or you cause it to be used, or you let somebody else use it when A, the condition of the vehicle, its trailer, accessories or equipment, or the purpose for which it's being used, or the number of passengers it's carrying or the manner in which they are carried, or the weight, the position, the distribution of the load, or the manner in which it's secured, is such that use of the motor vehicle or the trailer involves a danger of injury to any person. So if you've, let's say, hit a wall and the alignment of the steering is way out, or the tires are damaged, or the suspension is damaged, or let's say one of the seatbelts has jarred, as they do when you're involved in a collision, and therefore the seatbelts no longer work, they're no longer safe. Or let's say perhaps even one of the passenger airbags has deployed. I don't know if or why one would deploy and not the driver's one, but let's say that that's what happened. Any of those kind of things would come under this section because the condition of the motor vehicle, or the trailer, its accessories or equipment or anything else, or the purpose or the passengers, the weight, the distribution, etc. Any of those things involves any danger of injury to any person that could be within the vehicle or out with the vehicle, then this is an offence if you use it, cause it to be used, or permit another to use that vehicle or the trailer on a road. And that is notwithstanding that you might have a valid MOT certificate. Because if you were stopped by the police, for example, and they asked you why the vehicle was in an unroadworthy condition, it is not a defence to say to the officer, it's not necessarily a defence. There's one possibility which I'll come back to in a minute. It is not automatically a defence to say to the officer that I have an MOT certificate, here you go, you can check it online, it's valid, it was done yesterday or this morning or whenever it was. If you say that it's got a valid MOT certificate, it is valid at that point in time that it was tested. Now, if the vehicle as it currently stands is in a dangerous condition and poses a danger of injury to any other person, inside or outside of the vehicle, you might then be liable for an offence. Now, this for passenger vehicles is a fine of up to £2,500, and it is an unlimited fine for goods and services vehicles. And you also attract points on your driving licence. And if you repeat this offence within 3 years, there is a mandatory 6-month disqualification period if you are prosecuted for the same offence. Now, I did say that there are two defences. One of them is much more obvious and is possibly more difficult to prove because it is a point of fact which will be in dispute. And the second one, you quite literally may not know about. So dealing with the first main defence to this is if you just deny that this vehicle is in a dangerous or unroadworthy condition. This is a question of fact. Now, it either is or is not dangerous to use in that condition. So if you were prosecuted and if you deny that charge, the burden would then be to show that, in fact, it is not in a dangerous condition and therefore you deny the charge. This can come about in one of two ways. You are either outright denying that there is a defect at all, or you accept that there's some kind of a defect, maybe part of the front bumper's flapping because you've hit a wall. Police officer says that's dangerous. You say it isn't, hypothetically. Then you might agree that there is a defect to the vehicle, but you might deny that it's dangerous. So your denial in that sense might be that, yes, I accept that there is something wrong with the vehicle that may not pass an MOT, but doesn't amount to being dangerous. And so if it's not dangerous, that's your defence, and you might decide to argue that in court. Now, as with many, if not all of these things, it comes down to a question of fact, and every case is decided on its own merits and turns on its own facts, and invariably you're going to end up with your expert report or their expert report discussing together, or one expert that you both agree on and makes the decision. And in any event, it would be a good idea for you to get your own independent expert report, because if it turns out that your expert believes that it was dangerous, then you might be better off admitting the offence. Moving on to the second defence, which might be common sense, but which you might not know about, is found as a statutory defence under Section 48 of the Road Traffic Offenders Act 1988. This is an exemption from disqualification and endorsement for certain construction and use offences, including that under Section 40A of the Road Traffic Act, which is using vehicles in a dangerous condition. Under this defence, if you can prove that you did not know or you had no reasonable cause to suspect that the vehicle used might be a danger to another person, which I'll come back to in a moment, then if you can show that, the court must not order you to be disqualified and must not order any penalty points to be endorsed on your driving license. Now, coming back to the did not know and had no reasonable cause to suspect that the vehicle posed a danger of injury to any other person. But this is where it gets a little bit difficult, because if you've driven into a wall and it's damaged something internally in the vehicle, like the suspension or something else that might make it dangerous, let's say the coupling of the wheel, whatever the technical term is, and that makes it a danger of injury to other people, but you do not know about it, the second part of this test would probably fail. Because if they can show that it did result from you colliding with a wall, you might have a reasonable cause to suspect that the use of the vehicle involved some kind of a danger of injury to some other person, because you've driven it into a wall. Likewise, if you've had a collision with somebody and it's more than just a scrape, then you might not have had a reasonable cause to suspect that it involves a danger of injury to another person. Only if there is superficial damage or markings to the vehicle and doesn't give you any reasonable cause to suspect that it involves a danger of injury to another person, this defense might come about. The more plausible explanation under this defense is, for example, you've had work done on the vehicle for maybe repairs or routine work, you've had something replaced, but in doing so, they've done it badly. They've not carried it out with reasonable skill and care, for which you'd have a parallel civil claim for not doing it properly. This might still then pose a danger of injury to another person, but you don't know about it because you can't see inside the vehicle. You're not a mechanic. You've trusted them to do the work. You've had every faith because you enter contracts in good faith that they will do the work. If they've signed it off, particularly if they've signed it off, and particularly if you've been given an MOT certificate subsequent to the repairs, you would then have good evidence to show that you didn't know and had no reasonable cause to suspect that the vehicle posed a danger of injury to any other person. If the vehicle were examined by police, they look underneath and they say, this bit of whatever it is poses a real danger of injury to other people, you could say, well, I didn't know that, and I had no reason to know that. That's the common sense bit kicking in here, because this is why it is so very clearly worded. If you do not know and you have no reasonable cause to suspect that the use of the vehicle involves a danger of injury to any other person, then the court must not disqualify you or order penalty points on your license. Because it wouldn't be fair. Because if you didn't know and you had no reasonable cause to suspect it, then the court will not do that. It doesn't necessarily mean that you're off the hook completely, because the wording of Section 40A is fairly strict. What we usually refer to as a strict liability offence, because it says a person is guilty of an offence if he uses, causes, or permits another to use the vehicle or trailer, if the condition is such that it is danger of injury to other persons. Now, that is strictly worded. It doesn't say if you knowingly use it when it's a danger of injury to another person. It is a strict liability offence according to the wording of this legislation. But the exemption kicks in because it says, although you might be technically guilty of the offence, it would be unfair to punish you if you didn't know and had no reason to suspect it. Although the likelihood might be that if you can prove that you didn't know and had no reasonable cause to know, the court might then decide to dismiss the charge. But that's not a guarantee because, as I say, the wording of this offence is strict. You are guilty of an offence if you use, cause or permit to be used the vehicle or trailer in any of those conditions such that it involves a danger of injury to another person. It is strictly worded so to catch everybody, and there's a get-out clause if you can show that you didn't know and had no reasonable cause to know. But coming right back to the original point of this video, getting an MOT certificate is the easy bit. Because once you get the MOT certificate, it is a certificate of roadworthiness of the vehicle and the condition of the vehicle at that moment in time. And many people then just go on their merry way thinking that it is safe until they need to test it again. And many people then think that if there's damage to the vehicle, they don't need to get it repaired until just before they get their next MOT certificate, and then they can get it repaired and retested for a new MOT. This is, with respect, just as misconceived as some people that think that they get a certificate of cover for insurance, and then, believe it or not, people do this. They've genuinely come to us having done this and get into serious trouble for it. They take out an insurance policy, they get the certificate of cover, then they cancel the insurance policy thinking that they remain insured because they've got the certificate. They think for some reason that they've happened upon this marvelous loophole of car insurance so they can get free insurance somehow. Believe me, to a lot of you, most of you, I hope, that will sound quite ridiculous, because it is ridiculous. If you cancel the policy is null. It doesn't exist anymore. The fact that you have in hand a printed copy of the certificate of insurance or the cover note for insurance doesn't mean it remains to be insured. The insurance is a question of fact. Now, as a bonus tip for this video, I would recommend that you all make sure you double check the renewal of all your insurance. Make sure they actually take the money, because some people will get the email to say that they're going to take the money and renew their insurance, and then actually the insurance company doesn't, for whatever reason, doesn't take the money for the insurance, and therefore the insured wrongly believes that they are insured, even if they've received the certificate of cover, and then they fail to take the money. They go on about their merry way, thinking, well, I've got my insurance, it's their fault they didn't take the money. It isn't the insurance company's fault. It is incumbent on you, the driver, to ensure that you are insured while you're driving. And just having that cover note, while on the face of it, it's been insured, it is still incumbent upon you to make sure that it's insured for that duration. Now, if they haven't taken the money, you'd better be ringing them up to say, please take my money, please make sure it's insured and insured for everything that you intended. That's a subject for another video. But so make sure you subscribe for that one. A bit of a horror story, but I'll be coming back to that one. And I'll be naming and shaming in this one as well, because once it's dealt with, I will be speaking quite wholeheartedly about what happened. But in the meantime, don't fall for those mistakes. Make sure you check all of those things. Make sure if you've been involved in a collision or your vehicle's damaged in any way whatsoever, make sure you get your vehicle checked again straight away. And if it were me, I would get it re-MOT'd just to prove that it's roadworthy. And then if it is found out that it's in a dangerous condition, you can then say, well, I had no reasonable cause to know because I got it repaired and I got a new MOT, even if it wasn't yet due. Which brings up another interesting bonus point, because if you get an MOT up to a month minus a day before it runs out, you can keep the same renewal date. Otherwise, it will run a year minus a day from the date that it last passes the MOT. Again, all of these details are on the website. In other words, if it gets damaged and you get a new MOT, it runs from then, unless it's within a month of the anniversary of the last test. As I say, details on the website. So I hope you found that useful. Please do hit the subscribe button, help my channel grow. And as always, thank you for watching.